Hi, I'm Brooks Bossong, and I work with Nexon Pruitt's financial institutions and creditors' rights practice groups. Today, we're going to talk more about receiverships in the commercial loan context. This is the second part of a two-part series on receiverships. As noted in the first part, a receivership is a state court action used by a secured creditor to have a receiver appointed to take control of and preserve collateral when a business loan is in default. In exigent circumstances, a lender can obtain a receivership order from the court without notice to the borrower, so that the borrower does not know the receivership is in place until the receiver's management team, with the sheriff, appears at the borrower's office to take over operations. Typically, this is done when the loan is in default and the collateral is being mismanaged by the borrower, where there's evidence that the owner guarantor is siphoning funds from the borrower. Commercial loan documents almost always have provisions allowing for the appointment of a receiver under these circumstances. All of the above said, the borrower can still contest the receivership in court, but if the receiver was appointed without notice to the borrower and the receiver has taken control of the collateral, the borrower will be contesting the receivership from a position in which the borrower no longer has control of the collateral. It's not unusual for commercial loan documents to provide for receivership as a remedy upon default without specifying the type of default necessary to trigger receivership, meaning that if the lender can show a simple default, contesting the receivership automatically becomes an uphill battle for the borrower. Now, there is a way a borrower can bring an immediate halt to a receivership and regain immediate control of the collateral, and that's by filing a Chapter 11 proceeding. However, if you're a lender and your entity borrower and your collateral are clearly being mismanaged by the borrower and its owners, forcing the borrower into Chapter 11 is not a bad alternative to receivership. Last year, North Carolina's governor signed the North Carolina Commercial Receivership Act into law, which took effect January 1 of this year. Prior to that point, it had been decades since North Carolina's receivership statutes, which were never robust or comprehensive to begin with, had been overhauled. This new receivership legislation, on the other hand, is very comprehensive and provides direction on many points where the prior legislation was silent. What I've described in this two-part series is a very simple overview of receiverships in the commercial loan context. While a typical receivership is a very involved and complicated process, it is a very effective remedy, and in some cases, a very critical and absolutely necessary remedy that enables a lender to avoid continued mismanagement by the borrower and will regain control of the collateral before the collateral loses significant value. If you have any further questions regarding receiverships, please don't hesitate to give us a call.